My name is Jeff Morgan. I'm from Dallas, Texas. I want to speak about a case here filed by Cody Neal Taylor. He's the plaintiff versus Erica Duckworth and Lee Piaster. The case number here is 23DCCV0756. It's in the 172nd Judicial District in Jefferson County, Texas. This is the plaintiff's amended petition, 91A dismissal of defendants, counterclaim, and request for sanctions. This is a very important case, I think, and so I'm going to read a part of it, the first 4 pages of it, basically. If anybody wants it, they could probably contact me with this, give me your email, and I'll send it to you, or hit me up on Facebook, and I can send it to you that way. But it's very important. Mr. Cody Taylor, who I know, who's a friend of mine, I've known him for a couple of years, interviewed him, testified with him in front of the Juvenile Justice and Family Issues Committee, read some of his transcripts, read his petitions and stuff like that. Outstanding person, fighting to see his daughter. That our system, our family court system, our anti-family court destruction industry system has made it very difficult, if almost impossible, for him to see his daughter right now. And Cody is fighting back. Very knowledgeable guy, very determined guy. He is going to keep fighting this until the end. So here is what he wrote. And again, I'm just going to basically read the first 4 to 4.5 pages of this. To the Honorable Judge of said court, now comes Cody Neal Taylor, plaintiff herein, filing plaintiff's amended petition, 91A dismissal of defendant's counterclaim and request for sanctions against Erica Duckworth and Lee Piaster defendants based on violations and injurious acts by defendants including fraud, negligent misrepresentation of facts, and fraud upon the court with malicious intent. From what I've seen of, when I've interviewed Cody, the stuff that I've seen, I think all of these complaints are spot on, and I hope he wins, that he routs both of these people, and that he gets everything he wants from this. The defendant's actions and testimony were malicious with purposely knowing and recklessly defrauding the plaintiff by intentionally making false representations of material facts and concealing material facts in an ongoing child custody case. The case is proven as shown below. Number 1, discovery control plan level. The plaintiff intends that discovery be conducted under discovery level 2. Parties and services, second part here, plaintiff Cody Neal Taylor brings this action. Plaintiff resides in Jefferson County, Texas. The defendant is Erica Duckworth, a licensed professional counselor with her principal place of business located at 350 Pine Street, Suite 760, Beaumont, Texas, 77701. And the other defendant is Lee Piaster, is a secretary for the above professional at the business located at 350 Pine Street, Suite 760, Beaumont, Texas, 77701. The service of process on defendants will be through electronic filing of legal representation. Next talks about jurisdiction and venue. The subject matter in controversy is within the jurisdictional limits of this court. Point 6, the court has jurisdiction over the parties because the plaintiff resides in Jefferson County, Texas, pursuant to 15.002 of the Texas Civil Practice and Remedies Code, along with the incident location being at the 317th District Court, Edison Building in Beaumont, Texas, and allegations to the Beaumont Police Department. Number 7, venue is proper in Jefferson County because plaintiffs reside in Jefferson County, Texas, and the defendant's principal place of business is in Jefferson County, Texas, along with the actions described in the suit happened in Jefferson County, 317th District Court, Texas. So now he's going to discuss the background of his case. Point 8 says this: plaintiff is father of a minor child, SCT, age 10. Plaintiff was divorced from the mother of the child, Heather Rose Tice, on February 16, 2016, and the parties were named joint managing conservators along with joint rights and duties. Since June 13, 2019, over 3 years later, and continuing to this date, plaintiff and Ms. Tice have been involved in an acrimonious child custody case under cause number C223 529-C and concluded in the 317th District Court of Jefferson County, Texas on November the 21st, 2022. Point 9. Beginning around June of 2019, Ms. Tice entered into a contract and hired Duckworth, Erica Duckworth, the defendant in this case, in an effort to build her case against plaintiff, and began providing the child with counseling services. Throughout the course of the case, defendants provided malicious, fraudulent, and deceiving testimony, affidavits, and/or evidence in support of Ms. Tice's effort to limit and later restrict plaintiff's parenting time with his daughter. Now, from everything that I could see and what I read in the case and everything else, this was an intentional design by Heather Tice to try to kick the father out of his daughter's life. Unfortunately, our state often allows this. Texas allows this. Our legislators allow this by creating the statutes that permit this. Our judiciary appears to sanction it, loves it, and embraces it, as we will find in just a few moments. Point 10. Duckworth chose to bypass her licensed statutes and ethics to provide the court with misleading evaluations, testimony, reports to law enforcement, and opinions in which she was never in the position to provide. A licensed practical counselor, LPC, an LPC violating the codes and ethics of her profession. On December 13th, 2019, Duckworth, Tice, and plaintiff were present for a child's therapeutic session, after which Duckworth and plaintiff would have a discussion without Tice or child present in her office. Number 12, on January 13th, 2020, plaintiff would sign required documents for defendants to complete request of records at the defendant's place of business, Edison Building. Point 13, on January the 14th, 2020, defendants would make a false report of, quote, danger and fear toward plaintiff to Beaumont Police Department of alleged incident of January the 13th, 2020. Point 14, on January 27th, 2020, Duckworth submitted a sworn affidavit attached to Mrs. Tice's filed temporary restraining order request, thus resulting in Judge Larry Thorne, to issue an order restricting access of plaintiff and his daughter. Point 15, on February the 4th and 6th, 2020, defendants both provided testimony in a temporary restraining order, TRO, hearing sought by Ms. Tice. Duckworth would provide testimony under the title of, quote, expert witness, while Piastre would merely provide testimony of, quote, fact of interactions with plaintiff. Per the testimony rendered by both defendants, Judge Larry Thorne would rule in favor of Ms. Tice's request to restrict plaintiff's parenting rights, access, and time with their children. Malicious, falsified, and misrepresented facts during both defendants' testimonies would lay the foundation to deceive Judge Thorne, the, quote, fact finder, and persuade him to rule against plaintiff and violate numerous codes, ethics, and laws that bound the witnesses to give honest and truthful testimony while on the stand. Both defendants made a choice to completely lie to the courts of events, interactions, counseling sessions, fraudulent information to police, and others to gainfully impact the court in a false manner. Point 16. On February the 12th, 2021, Judge Thorne issues a second TRO, temporary restraining order, with the previous TRO recommendations by Duckworth. And Judge Larry Thorne said this: "It is not me saying that you shouldn't have access. It's professionals that are telling me, and so I have to go by what the professionals basically said." Thus, he completely restricted access of the plaintiff and the child for 11 plus months with a no contact order in place. Now, for those of you who think that the judge has discretion in all of this stuff, and I've heard this on multiple occasions, again, recently, within the last 2 months, when a judge said, well, I have to pay attention to what the experts are telling me. I believe it was a couple of times, a judge said that we are bound to go by what the experts tell us. So the judge can't even use his own discretion or her own discretion. The judge has to listen to so-called experts in their field. They're the real judges. They're the real ones that are making decisions in family court or anti-family court, as we've talked about. And this is what Judge Larry Thorne said. He gets to hide behind the so-called expert testimony witness of these professionals. Whether she's an expert testimony witness or not, whether she lied to the court or deceived the court or misrepresented herself to the court or committed fraud upon the court, I am not in a position to know. But these, I believe, are what the allegations are. On June 16, 2021, Dr. Kit Harrison completed court-ordered child custody evaluation, which upon his conclusions granted plaintiff parenting time be reinstituted immediately. Claimed Duckworth hated the plaintiff. This is what the child custody evaluator, Dr. Kit Harrison, is saying that the Duckworth, Erica Duckworth, hated the plaintiff, and she used, quote, junk science. She, quote, left her role of a therapist. She, quote, should not have made the recommendations. And, quote, there is no material fear or danger with the father, period, end quote. Dr. Harrison would submit a written report to the court in October 2021. On December 14, 2021, Dr. Harrison would further testify to his findings about the violations and gross misconduct by mental health professionals, but would specifically point to Duckworth as biased toward plaintiff, stating, quote, she was never in a role that would permit her recommendations, opinions, anything other than the course of treatment and progress in therapy. She was the child's therapist. That's the most limiting role there is. No opinions, no recommendations. She never evaluated either parent. She had no basis in scientific or forensic validity to offer any opinions about the child's best interest, end quote. Dr. Harrison again would state that the child should have been back with the plaintiff 6 months ago and that it is continuing to affect the child. Point number 19. On August 24, 2020, jury trial testimony, Dr. Harrison testifies again to the same egregious and non-forensic recommendations by mental health professionals, stating again the gross statutory violation by Duckworth, LPC Erica Duckworth, for the role she played in restricting plaintiff and child's access, possession, and time together. Dr. Harrison consistently states, quote, no therapist working with a child should have anything to say related to conservatorship, access, or possession, end quote. Regarding Duckworth's intent back in 2020, Dr. Harrison repeated multiple times throughout his continued testimony. In this case, the child suffered from, quote, perceived abandonment by the plaintiff. This stems from the defendant's actions in this case of malicious nature and no intent but to harm plaintiff in pursuit of a legal agenda for the mother. Point 20. Defendants were not called as witnesses due to their gross and malicious actions that took a court-ordered child custody evaluator to recognize that they were not being truthful, professional, and had clear bias against the plaintiff. Neither defendant would serve as a fact or expert witness when they played such a monumental role in separating the plaintiff, Cody Neal Taylor, my friend who I know and who others know, being a man of integrity, an outstanding father, separating him from the child. Now there's a lot more that I could read here. I'm going to stop this right here. My understanding is right now is that Erica Duckworth is trying to sue Mr. Taylor for misrepresenting her or slandering her or something like that, and that's why this whole this petition is being raised to the court. So anyway, I will tell you that from my perspective, again, I know Mr. Taylor. I've known him for a couple of years, talked on multiple occasions with him, emailed him, texted him on the phone, in person, interviewed with him for 2 hours. I broke it down into 13 different segments so that it would be easier for listeners to follow. Testified alongside of him in front of the Juvenile Justice and Family Issues Committee. Mr. Taylor is an outstanding father. I stand with Mr. Taylor, and based on the affidavits that he has received for his case, there are other people that stand with Mr. Taylor as well. I'm going to talk about some of these affidavits in just a moment, but one of the reasons I'm bringing this up in particular is I've learned something recently, that we can now file complaints against these people based on videos that are out in the media. Again, this is from what I've heard. I don't know this from firsthand fact, but I have heard this through another person that I trust, that basically if we start filing complaints against, whether it be judges, licensed practical counselors, or whomever, attorneys, based on videos that are out there, that perhaps these complaints get elevated to a different level. Because at this point, once we start filing complaints based on media, and I do consider myself media, I have over 2,100 videos out on my YouTube channel. I've been doing this for 7.5 years. I was considered a media consultant for Dad Talk Today. I've done a lot of things, been to a lot of conferences, have helped to orchestrate interviews, have interviewed people of all walks and ages and everything else. So I do consider myself media, but once the media narrative is out there, all of a sudden they realize they cannot control the narrative. So we need to start filing complaints, even if we have first-hand information. Use the first-hand information, and also feel free to reference this video and the upcoming 4 videos that I'll be doing with regard to the affidavits that have been submitted on behalf of Mr. Cody Taylor. And perhaps there will be things that will be taking place here that will make things better, not just for Mr. Taylor, but for all parents throughout the state of Texas, and helping to reform our system. Thank you.